Hello friends, welcome back to my channel Quest for Knowledge. So today we are going to discuss important 5 marks and 15 marks. Explain exceptions to rule no consideration, no contract. So a contract without consideration is void. Are there any exception to this rule? So we are going to discuss the exception. So no consideration, no contract. As per the section 25 declares, an agreement made without consideration is void. It means it is not going to be a valid contract one. It means that consideration is must in all cases. Exceptions are written and registered agreement out of natural love and affection between the parties, like if you are gifting something, okay, and promise to compensate a person who has voluntarily done something for the promiser. Example, promise to pay time back debt, completed gift, or creation of agency. Now second question, distinguish between condition and warranty. Okay, the difference is in condition is essential to the main purpose of contract. Warranty, it is this only subsidiary to the main purpose of the contract. Breach of condition entitles the innocent party to repudiate the contract. So if there is any kind of a breach in the condition, okay, then the innocent party can sue and he can repudiate. It means he can ask for the compensation. But in warranty, breach entirety entails the innocent party to sue for damages. So the word repudiate means to refuse to believe on something. So in the breach of condition, the innocent party can refuse to accept, but in the warranty, he can sue for damages. A breach of condition may be treated as breach of warranty, but a breach of warranty cannot be treated as a breach of condition. So there is no vice versa. A breach of condition may be treated as warranty, but the warranty cannot be conditioned as the breach condition. This is the continuation question. Okay, write about the difference between the misrepresentation and fraud. So there is no intention to deceive, and it is a false innocent statement, that is misrepresentation. When you have the intention to deceive somebody with a false statement and you have made it deliberately made false statements, that is completely a fraud. Person who makes statement believes it to be true. Misrepresentations, okay, we believe it to be true, but person who makes statement does not believe it to be true because he wantonly is wanting the other party to believe onto it. Here the contract becomes voidable at the option of the insured party. Okay, if he wants, he can, because of the misrepresentation, he can agree with the contract, or else he may refuse with the contract and make it a void one due to the misrepresentation. Here in the fraud case, the contract becomes completely voidable if it gives the right for an independent action in tort. It is completely voidable. It is like, it is voidable which has the chances to get valid in misrepresentation, but in fraud it is surely going to be voidable. What are the objects of COPRA Act 1986, that is Consumer Protection Act 1986? So object of the act is to protect the interest of the consumer, to protect the right of the consumer regarding marketing of goods and services, quality of goods and services, and price of goods and services, to protect the consumer against any kind of unfair trade practices, to set up consumer protection council at the center and state level. He has the right to get the council also. To set up quasi judicial machineries to provide speedy, simple and less expensive redressal to consumer disputes by giving reliefs and compensation to consumers, and to enable consumer to use his right to consumer education. Okay, now we'll discuss what are the objectives and features of Fema. So FEMA stands for Foreign Exchange Management Act. The Parliament enacted the Act in 1999 to replace the Foreign Exchange Regulation Act 1973, which is FERA. Okay, the main objective of FEMA as follows, which is first to facilitate the external trade and payment, and to promote orderly development and maintenance of the foreign exchange market in India. Second is to introduce more liberal provision in keeping with the requirements of liberalized regimes to make it more non-restricted one. After that, to facilitate more external trade and payment, to promote the orderly, we have done, to deal with the foreign exchange. It's as it is foreign exchange, it's all about to deal with the foreign exchange, to regulate import and export of the currency, to regulate acquisition, holding of immovable property in India by the non-resident, to regulate proper payments, to regulate employments of foreign nationals, to conserve the foreign exchange resources of the country, and to utilize the same in the interest of the economic development of the country. So these all are the objectives of FEMA. So this is the very important question, consumer redressal agency. So first we have a district forum, state commission forum, and a national commission. Okay, so first of all, a district forum is set up by the state government, and the state commission is being formed in every state, and a national commission which is set up by the central government. So first we'll understand the district forum. In this we have constitution, composition, appointment, qualification, period of office, terms and service, and jurisdiction. So constitution, it is set up by the state government on each district. Okay, its constitution. Composition, it shall have president and two members, and one of whom must be a woman. Appointment, they are appointed by state government on the recommendation as per the selection committee of three persons. The selection commission person has a chairman and two members. The chairman is the president of the state commission. One member is the secretary in the law department and the state, and the another member is the secretary of consumer affairs of the state. Now, what will be the qualification? The president of district forum must be a qualified district, okay, and judge, and the other two members must have the ability and integrity and have enough knowledge and experience in economics, commerce, accountancy, law, industry, and public law. After that, period of office, every member of district forum shall hold office a period of 5 years, and there shall be no reappointment. Terms of service, the salary and terms of condition of the service, the member may be prescribed by the state government. What will be the jurisdiction? The jurisdiction is based on the amount of compensation. The jurisdiction is limited to the extent of compensation value of up to 20 lakhs. Okay, now we'll discuss the state commission. First, we'll have the constitution. As we all know that it is set up by the state government. Composition, it shall have a president and two members again, and one must be a woman, same to same. Appointment, the president is appointed by the state government, okay, and from with the constitution with the chief justice of the high court. So they are appointed by the state government on the recommendation of a selection committee of 3%, again as we discussed in the same district forum. What will be the qualification? He should have to be a judge of high court, and he is appointed by state government. The qualification of the two members is as same as in the case of the district forum. Okay, it means they should have a good knowledge about the law, commerce, public law and all. Period of is as same as the district forum. Terms of service, it is also prescribed as the state government as in case of district forum. You have to write it, okay, don't write as prescribed by the state government. Whatever there in the district as it is, you need to write it. After that, jurisdiction, the jurisdiction of the state commission is limited to the extent of compensation value, the same, not more than above 20 lakhs in the district forum and up to 1 crore in the state one. Okay, treatment of complaint, the rules of section 12, 13, 14 of procedure explained under district forum may be applicable to the same state committee as well. What will be the power? It has the power of a civil court, and it can call for the records and appropriate order in any consumer dispute pending before it, and also decide by any district forum within the state. It can issue an order to the party directly to do one or more things referred under section 14. The aggrieved party can appeal. Okay, the aggrieved party can appeal against the order of the commission within 30 days. Okay, and from the date of order in the National Commission. Now we'll discuss the National Commission. Constitution is from the central government. Composition, president and 4 members here. Okay, and 1 woman. So make a difference. Appointment: the president is appointed by central government, and chief justice of India of the Supreme Court, he should be a judge of Supreme Court, and other members are appointed by the recommendation of the selection committee. As we all know, 1 chairman, 2 member, but they should have to be here from Supreme Court. Why? Because it is the national one, and the other 2 members should know very good under the Department of Law, Government of India, and another member should be the Department of Consumer Affairs. What will be the qualification? He should be a judge of a Supreme Court and he is appointed by the central government, and other four members must have the ability and integrity and have some knowledge and experience to economics, commerce, accountancy, law, industry and public affairs. So period of office is same as the state commission. Terms of service: the salary and terms and conditions of the service of the member of National Commission is prescribed by the central government. Place of office is that commission must be in the state of Delhi. Jurisdiction is limited to the extent of compensation value of 1 crore, and appeals goes with the order of any state commission. Treatment of complaint is same as the district forum. Power: that as per the section 22, it has the power of a civil court, and it can call for the record and issue an appropriate order in any consumer dispute. You need to write the same. An appeal is section 23. Any person aggrieved by the order of the National Commission may appeal against such order in the Supreme Court within 30 days from the date of the order. What are the objectives of passing the Environment Protection Act? So the history of Environment Protection Act is that environment agencies. Environment Protection Act 1986 was constituted on 19th of November 1986 to provide the protection and improvement of environment for matters connected with environment. So it was formulated by the central government for the protection and improvement of the environment in India and for matters connected therewith. It was introduced after the Bhopal gas tragedy. The Government of India has enacted this Act under Article 253 of the Constitution. So it is an umbrella legislation designed to provide a framework for the central department to coordinate activities of various states and central authorities established for the previous environmental law, such as the Air Prevention and Control of Pollution in 1981 and the Water Prevention and Control of Pollution Act 1974. So what are the objectives of the Environment Protection Act is, first of all, the purpose of the Environment Protection Act is to implement and take decisions of the United Nations Conference on Human Environment to protect and improve human environment and to prevent hazards. The main objective of the Environment Protection Act is to provide protection and improvement of environment, and it specifies that the state shall protect and improve the environment. It also aims to safeguard the forest and wildlife of the country, and it's an umbrella legislation designed for central government. Now, what are the briefly state the constitution, composition and object of consumer, or the question can be briefly explain the constitution, function of Central Consumer Protection Council. Any one of the question, but the answer will remain same. So the Consumer Protection Council, there are 2 Consumer Protection Council, one at central level and one at the state level. First we'll discuss the Central Consumer Protection Council. First is the Constitution. The central government by notification may form a council known as Central Consumer Protection Council. Composition: It shall have 150 members, namely Central Minister in charge of Consumer Affairs will be the chairman, Minister of State in the Department of Civil Supplies without independent charge will be vice chairman, 8 MPs, 5 from Lok Sabha and 3 from Rajya Sabha will be the part of it. Commissioners for SC and ST, 20 representative of central government department and at least 20 representative of the consumer organization, at least 10 representation of women, 20 representation of pharma, trade, industry, 15 representation of the capable of representing consumer interest. The secretary in the Central Department of Civil Supply shall also be the secretary of the Central Council. Meeting of the Central Council. The council shall meet at least once in every year. And so we'll discuss the objects: the right against marketing and hazardous goods and service, the right against unfair trade practices, the right to get various goods and services at competitive prices, the right to be heard to ensure that the consumer interest receives due consideration as different forums, the right to be redressed against unfair trade practices. So these all are the rights. Objects. Okay, after that, State Consumer Protection Council, again its constitution, composition, meeting and objects. The constitution is formed by the state government by the notification, a council known as State Consumer Protection Council or State Council. Composition: it will have the state ministers in charge of consumer affairs as the chairman and member nominated by the state government. Meeting: they should have at least twice in every year. The time and place of the meeting is decided by the chairman. Object is to promote and protect consumer rights. Now the question is, explain the provision relating to revocation of patent. Subject to the provision contained in this Act, a patent, whether granted before or after the commencement of the Act, may, on the petition of any person interested or of the central government or a counterclaim in a suit for infringement of the patent, be revoked by High Court on any of the following grounds, that is to say, that, for example, invention, and it is claimed in any claim of the complete specification, was claimed in a valid claim of earlier priority date, contained in the complete specification of another patent granted in India. The patent was granted on the application of a person not entitled under the provision of this Act to apply, therefore, provided that a patent granted under the communicate or the importer of the invention in India and therefore not entitled, make an application for the grant of a patent under the Act. That the patent was obtained wrongfully in contravention of the right of the petitioner or any person under or through whom he claims. That the subject of any claim of the complete specification is not an invention within the meaning of this Act. That the invention, so far as claimed in any claim of the complete specification, new, having regard to have publicly known or publicly used in India before the priority date of the claim, or what was published in India or elsewhere in any of the document referred to in section 13, provided that in relation to patent granted for the Indian Patent and Design Act 1911, this clause shall have effect as if it is not there or elsewhere had been omitted. Invention, so far as claimed to any claim of the complete specification, obvious or does not involve any invention step, having regard to what was publicly or publicly used in India and was published in India or elsewhere before the date of the claim, provided that in relation to patent granted under the Indian Design Act 1911. This clause shall have effect as if words of elsewhere been omitted. This is all about patent, like how you can claim for any kind of a you can claim for your patent The complete specification does not sufficiently and fairly describe the invention and the method by which it is to be performed. That is to say, that the description of the method or instruction for the working of the invention as contained in the complete specification are not by themselves sufficient to enable a person in India possessing average skill in and average knowledge of the art of which the invention relates to work the invention, or that it does not disclose the best method of performing it, which was known in the applicant for the patent and for which he was entitled to claim protection. Scope of any claim of the complete specification is not sufficiently and clearly defined, or that any claim of the complete specification is not fairly based on the matter disclosed on in the specification. So, patent was obtained on a false suggestion or representation. The subject of any claim of the subject complete specification is not patentable under this act. So, in what and all manners it is not patentable, or it will affect the patent of yours if you have patented, but it has been already used somewhere else in India or outside of India, then it will be the petitioner can claim for the patent over there which the person has patented under his name. So such kind of these all are the you need to write the various acts where the patents can be valid or void. So what are cyber law? Explain the claim and objective of the act. Cyber law is an act which provides legal recognition for transaction carried out by means of electronic data interchange and other means of electronic communication, generally known as electronic commerce. It provides alternative method of communication and storage of information to facilitate electronic filing of documents with government agencies. That is called as cyber law. So these all are the scope of cyber law, and following are the main objective. So scope, it is negotiable instrument, it's a power of attorney, okay, as per the Act 1882. A trust as defined in the section of the Indian Trust Act 1882, a contract for the sale or conveyance of a movable property or any interest in such property, any other class of documents or transaction notified by central government in the official gazette. Objective is to bring suitable amendment to prevent possible misuse, to safeguard the interest of the public, to make consequential amendment in the objective Indian Penal Code and Indian Evidence Act 1872 to provide necessary changes with regard to offences in relation to documents and paper based transactions. Now we'll understand what is the essentials of a valid essentials of a valid contract. We have two component: existence of an agreement and its enforceability, okay, for a valid agreement, and it can be free of consent. As you can see, first is the offer and acceptance. An agreement in the result of offer or proposal and acceptance as offer to do or not to do a definite act or act is made by one person who is called the offerer. The proposer is accepted by the other party who is the offeree. Second is the free consent. So it is not enforceable, and when they agree it with their free consent. Free consent is when offer and offeree are of the same mind and upon the same subject. Free consent does not exist when it is obtained by coercion, undue influence, fraud, okay, or misuse and misrepresentation. It should be free of consent, okay. They should be freely agreeing to the contract. After that, contractual capacity, both of the parties should be competent, they should be mature, they should be solvent, they should be sound minded. After that, it comes lawful consideration. They should not enter into any kind of a illegal contact which is completely illegal. So they should enter into lawful consideration, and their objective to enter into a contract should also be a lawful one. It should not be unlawful and not expressly declared void. The agreement must have expressly declared to be void under any law. So void agreements cannot be enforced by law. And possibility of performance, the act contemplated in the agreement should be capable of performance. Agreement to perform an impossible act cannot be enforced. Example, a promise to share be 50% of the treasure provided the treasure is created by magic. Such an agreement cannot be enforced because of impossibility of performances. Certainty of terms, the terms of the agreement must be certain. Vague or uncertain terms of agreement will make it unenforceable. A company agreed with V that on the expiration V's existing contract, the company would favorably consider a request of V for renewal of the contract. It will held the company had no obligation to renew the contract as the agreement did not bind the company to do so. Intention to create legal relationship. So whatever the contract they are trying to enter, the intention should be to create a legal relationship between them, not to create any kind of a illegal one. In agreement relating to business, the law will pressure that the parties have intention of legal relationship and legal formalities. They has to go as per the legal formalities, and registration is good, but it is not compulsory, but it is compulsory for gift and mortgages. So after that, that was the 15-mark question. This is the another important 15-mark question, which is the right of unpaid seller against the good. This we have already discussed. Now we are going to discuss in detail. Unpaid seller means who have sold the product and goods or services, but he has not received the price. So that is the unpaid seller. What is the right of an unpaid seller? The right of an unpaid seller is that first he has the right against the good, and second he has the right against the buyer. So right against the goods is that the right of a seller against the goods are as right in rem. So he has a lien or right of retention. He can retain the product, and he has the right to stoppage, to transaction the ownership from one person to another. He can stop it. He has the right to resell it to somebody. After that, he has the right to withhold the delivery. He cannot give the delivery. Why? Because it is not being paid, and he can hold the delivery until it is getting paid. So right of lien. Lien is a right to retain possession of goods until payment of the price. A lien on the goods for the price while he is in possession of them. In case of the insolvency of the buyer, a right of stopping the good in transit after he has parted with the possession of them. He has the right to resell it. Seller's lien is that where the good have been sold without any stipulation as to credit, where the goods have been sold on credit about the term of credit has expired, and a part delivery, if he has unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder. And seller's lien lost or termination of lien, the unpaid seller of goods loses his lien thereon when he delivers the goods to a carrier or other bailee for the purpose of transmission to buyer without reserving the right of disposal of the good. When the buyer or his agent lawfully obtain the possession of the good, and the unpaid seller has a lien thereon, not lose his lien by reason only that he has obtained a degree for the price of the good. Right of stoppage in transit, when the buyer becomes insolvent, he can stop the transaction. When the goods are in transit, then he can immediately stop the transaction. And duration of transit, it's like if it is in the course of transit from time to time, he has to provide the delivery. He can hold the delivery. Why? Because he has not got the payment. And if the buyer or his agent in behalf obtains delivery of the goods before their arrival at the appointed destination, they can end the transaction. After that, he has the right to resale that we have already discussed, right to withhold the delivery. So after this, what are the rights against the buyer? Okay, when the what he can do with the buyer, he can take him to the court, he can sue him, okay, as a person. With the buyer, what a seller has the rights. So first of all, he can sue him for the price, okay, like so and so payment has to be done for that price. He can try to get it through taking him to the court. After that, he can suit for damages for non acceptance. Why? Because if the buyer has refused to accept to pay for the goods, he can sue him for the damages, and then he can refuse to accept of contract before due date. So when the buyer refuses the contract before the date of delivery, then the seller can treat the contract in subsisting and wait till the end of delivery, or he may treat the contract as rescinded and sue for damages and breach of contract. And he can sue for the interest also, because he has completely played with the interest of the seller. Okay, like payment was due, so he can sue him and